Good morning. We're hearing our case 1, CV21-0331, entitled Hoobler versus Hoobler. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. That's why we have the clock at the podium. We are recording the argument both in audio and video, so when you come up to the podium to speak, please identify yourself and your client, so that if we're reviewing the argument in audio, we can keep track of who's speaking. The video will be on YouTube in a couple of days, so you can see how well you did. We've read the briefs, we've conferenced the case, we're familiar with the law and the facts. So when you begin your argument, just start off with what you want to talk with us about. Counsel, you may begin.
Morning. May it please the court, Keith Berkshire for the appellant Dale Hoobler. This case presents an interesting position between what is a mature or an unmature pension right, and also how you can distribute said pension when there's insufficient assets in the rest of the community to do a simple lump sum or cash out of the the outspouse's interest. Here what the court did basically a combination of a partial lump sum and essentially reserved jurisdiction in allowing then a smaller percentage of husband's pension through the typical process of doing a quadro and having the actual pension company provide the checks. We believe that this is not allowed given the case law under Johnson and Kelsch, and asking for remand for that the court simply divide the checks that come in when my client's out of drop, and the drop which the parties agreed to, the wife would get her 50%. We also...
I understand very well, and you make a lot of good policy sense, but we've got Kelsch and a whole bunch of cases that have said life insurance is one way of doing this, and I don't understand how we're supposed to find it to be an abuse of discretion when the Supreme Court and the prior panel I was on and other cases have said, well, life insurance is one way to handle this issue.
Well, again, the life insurance in Kelsch, the specific holding of Kelsch, the life insurance was only held to be valid for the Kelsch payments themselves, the payments that until the outspouse got the payments directly from the plan administrator. And the statements about that were very clear, and it was only in exceptional circumstances where they were not going to give the immediate Kelsch payment. So in Kelsch, the one side said, okay, you can just keep your percentage of the payments, but since your total benefit will be higher later, you don't get what we now refer to as Kelsch payments. And in that case, the Supreme Court said that was the limited circumstance that you could ensure those deferred payments was through life insurance because they were deferred, not just as a general security instrument.
It seems like this is a good case for this type of insurance policy from the standpoint that if husband dies after 3 years after retirement, there's nothing. And if there were a community interest and he had retired while they're still married, I'm assuming they could have taken a lower amount that would have included the life of the spouse. Is that I'm assuming that's typically how these work?
The public safety in this case, both the Supreme Court and Kelsch and Rick Underwood, who testified here, talked about that if the benefit for the new spouse or for the existing spouse is just 80%. It's 4/5 of whatever amount would be. So it's not like ASRS where you choose a 80-20 or a 50-50, life annuity. Public safety, it's just set at 4/5. So you're not taking like ASRS where you take a reduction, you get less of your pension, you take 100 or 80-20 or 50.
But wouldn't there at a minimum be a value, and I'm kind of curious if there's a valuation based on this 80%, that had the community had earned something that had they stayed married and he had died, she would have continued to receive 80% of the benefit for as long as she lived? So why wouldn't that be kind of a baseline?
That's the argument that went up to the Supreme Court Pareda, and the Supreme Court Pareda said, yeah, but that's not what the legislature did here. And that's the issue. This was, I'm always happy to use one of my old cases to support new ones, and especially Howell. But that's essentially the same argument that was made in Howell. We can just say, you have a benefit here, so let's indemnify. And the problem is that's not what the legislature said you get to do. Really interestingly.
But isn't that different than ahead of time trying to figure out how much did the community, what's the value of what the community has earned over a 25-year period? And so to say this is what the value of this retirement benefit, it would be 80%. So we've got to figure out a way to make sure if he dies 2 years later, she gets nothing. It seems like she hasn't received the benefit of everything the community contributed.
Well, frankly, either did he. He's dead. So, and if he doesn't have a new spouse, she doesn't get it either. So his estate loses the same way that his ex-wife did because he died. He didn't get the full benefit of any of that either. So she ends up getting it.
Well, that's not fair because he's not alive to need that.
Correct, but it's still essentially a benefit that could be passed to his estate. Just because, normally, property, which is what the Snyder v. Tucson case said, the opposite way, which was, well, you still have the value to your estate. So, she ends up getting a higher amount than he ends up getting because his estate gets less. But again, this still gets around the point of Pareda. Pareda went through all these arguments the same way and said, we get it, the community did earn it, the community did have this benefit. If they were married, the community would still have the benefit, but the legislature said, too bad that you don't get that because the legislature didn't give ex-spouses a survivor benefit. And it's just one of the things that, as the Supreme Court said in Pareda, legislature could fix this, the stroke of a pen immediately, and you'd have that right. But this is just this type of pension. That right doesn't exist.
So what does Pareda prevent the parties from ahead of time saying, we want to make sure everybody's adequately protected, so we'll get an insurance policy that will approximate what might have been paid.
I think that if the parties can agree to do whatever they want, so if that was the situation, you could agree to that. But the issue here, one of our claims is that the trial court's without authority to create a new asset. They didn't give him a lien against his estate. That's not what the court did to ensure payment, which I still contest is contrary to Pareda. But they made him create a new asset and go buy a new insurance policy. It's different than what Division 2 did in Mitchell, which was, hey, you can, that issue wasn't taken to the Supreme Court, so we don't know if it would have been overturned. But they said you can assign an asset that already existed in a life insurance policy. But it wasn't creating one. There isn't one. It's go out and get something new and pay post-service funds to pay part of the payments.
They ordered her to pay half of it, right?
Yeah, and him to pay, again, but he had to pay something for it for a period.
I feel like, and maybe I'm mistaken, but setting aside the Pareda/pension issues, couldn't the court have ordered him to maintain a life insurance policy?
I don't think so. Again, it's creating an asset. The court has the ability to assign, though not necessarily in kind. That's what Weaver says the limitations on the statutory authority under Title 25 are. This is creating something new. You might as well order somebody to go out. Under this theory, you could say, hey, there's an equalization payment. Husband, you have to take out a loan to pay the entire equalization payment off in the next 30 days versus it's just a judgment. So they're making you do some new post-decree action that is outside the scope of 25-318A. It's not assigning assets. That's the limit that the court has the ability to do. And again,
I guess the life insurance policy itself is an asset, but if the court had ordered, as part of the division of assets, I'm going to order you to pay 1/2 of a life insurance policy obtained by the wife against you, would that be a problem?
If you're making him have to go cooperate and get a life insurance policy, again, it's creating an asset on his life. The issue here is, again, I think one of the cases really truly that is most relatable to this is the Howell case, is this concept that somebody, like in Howell, that went through Arizona, and where the court says, okay, yeah, you're choosing to take your disability pay, which is getting around their vested property right in your military pension. 27 state courts said that the indemnification was fine. And the U.S. Supreme Court said no, that it gets around the point of the statute. The statute in that case said disability pay is separate property. The trial court can't get around a statute by just creating something else, which in that case was this concept of indemnification. Here it is, there is no survivor benefit for ex-spouses. So the court, having a life insurance policy, creates the survivor benefit. So you're just trying to find a very simple solution. It's simple. I mean, you could argue that to some extent it's equitable, but it's also contrary to the statute in this specific type of retirement. Again, Howell was a retirement as well. And if you weren't allowed to indemnify when somebody purposely chose to take disability pay to get around paying you, and in the two cases, Howell and Merrill, that both went to the Arizona Supreme Court, they did the same thing. And I mean, in Merrill, it was 90% of the wife's pension, my client was able to defer by taking disability payment. And again, the Supreme Court here said you can get around that by doing indemnification. The U.S. Supreme Court said you can't because it's contrary to the point of the statute, which is what, again, Pareda does say, that there is no death benefit. The community interest dies when he dies or when the in-spouse dies. And I think one of the, not on the insurance concept, on the other side, the cash value, where the court gave all of the 457, basically the 401k type accounts that were available to my client, it cashed her partially out. Again, that gets around it. The Kelsch is an interesting case from what actually occurred in Kelsch. And I don't think you could read Kelsch as broadly outside of what occurred. Kelsch was about Kelsch payments. Can you just wait to retire and therefore divest somebody of the payments they could have at that point? Kelsch isn't read that if it's mature, you have to cash value it. You have to present value it from a lump sum. The word present value in Kelsch was for the payments that would be due at that point. And specifically, when you get into the later sections of the Supreme Court opinion in Kelsch, what they actually held was that until he retires, he pays the Kelsch payments. Once he retires, the plan pays it because it's easier we know the present value is just what he's getting, and it's easy to calculate. So Kelsch actually, when you look at the facts of it, actually supports our position that what the court should have done was just divide the pension payments, because he's not, in this case, my client can't contribute anymore because he's in drop. So he's barred from it. So there's no working after the fact. He's barred. And there aren't Kelsch payments because she's getting them as drop. And actually, she's getting quite a bit more than the Kelsch payments would be. Frankly, if the Kelsch payments would have been better to be made for my client, because then he probably wouldn't be paying her spousal maintenance because she'd be receiving the same amount. But the Kelsch payments are covered by she's getting significantly more because of drop. And then the present value of the payments will be when 2 years from now she gets the checks directly from the public safety retirement system. So, the lump sum cash value concept in these cases, in Johnson and so forth, these were meant for when it's years in the future they're going to retire, and that the actual lump sum of the amount, when you just do a present value calculation of it, can actually be paid in full. The concept really is, let's divide people. Doing family court, that's understandable. You don't want to sit here for years and deal with these cases. It's why half the trial court's caseload is, post-decree. But that concept didn't work here because they didn't divide them. They gave a partial payment of the lump sum, and they still stayed together. So the concept of this is dividing them and getting them apart actually is the opposite. It didn't do it at all.
Well, what would the consequence to your client have been if the court had issued during the hybrid approach had done a lump sum?
Well, there's no ability to pay it. I mean, the lump sum amount, the court in Johnson basically said that if there's, sufficient other community assets to account for the entire judgment. Here it wasn't. There's not, the lump sum in there was, your lump sum's $100,000, you got $1 million of assets.
Yeah, it's just odd to say that makes sense on a theoretical basis, that the spouse is essentially getting half of the actuarial value of the anticipated pension. And the court seems to be trying to do that here. We want half the anticipated value of the anticipated pension. And the only way we can do that is by some other means, because there aren't enough assets in the estate to do that. So are you agreeing that if they were independently wealthy and had enough money, that it would have been appropriate to do an actuarial value of the pension to husband's pension and have a payment of half that amount?
If they had $10 million in community assets and husband was 10 years from retirement, and this was
let's say he's going to retire now. We know exactly what the retirement payment is going to be. Would that be a viable option for the court?
Potentially, if there were such sufficient assets that it didn't cause the undue hardship to husband, I think was the quote out of Johnson, that you could cash value it. Johnson was, present cash value is preferred if the pension rights can be valued accurately and if the marital estates include sufficient equivalent property to satisfy the claim without undue hardship. So it's the entire claim. So yeah, if there was 10 million of assets and she got $1 million extra because of this and they were there was no connection anymore, either through drop or the pension, then I think it's more of a claim. I think, again, the farther back from the retirement date, I think the better the claim is, that it should be present value, because, again, the idea is to disconnect the two.
What should the court have done? I mean, if we were writing on a blank slate, setting aside discretion, everything else, what should have the court have done?
Divided the 457, the 401k type plan, IRA type plans just equally, divided the drop equally, and just divided the pension when he gets it equally. His pension right was set. There was no, since he can't contribute anymore, we knew she's just getting 50%.
But she could have requested Kelsch payments, right?
And actually, in reality, frankly, in these cases, usually the Kelsch payments, she would have then got less drop, because the drop was the Kelsch payments, essentially. So the reason in these cases you don't see drop plus Kelsch payments is because the drop, he had to work for those 5 years to get the drop. So she is already getting post-service earnings because of the drop. It's just an alternative.
Did you point this out?
Rick Underwood at testimony testified all about the difference between a Kelsch payment and the drop, and basically that the drop accounted for the Kelsch payments. It's why you don't get duplicative, and that's what he testified to. You never see both, because it would be, the drop is post-service earnings. It's just instead of getting Kelsch payments, you get the cash retirement thing. So, but when you do the calculations, drop is actually more than the Kelsch payments.
Because they have an interest rate.
Yeah, because they have an interest rate on it. So it's actually higher. So it's usually, if you're the in-spouse, you're actually better off paying the Kelsch payments. Plus then, if they're getting the pension payment of, their portion of the Kelsch payments at $3,000 a month or $3,500 a month, the chance of getting spousal is less.
So if it was so simple, why did the court get so confused? If it should have just been easy 50-50 all the way through.
When I got that, I was asking the same question, because normally in these cases, they just defer it and you get your payments directly from, either ASRS or PSPRS or whatever. They don't normally do this. The argument was made by Ms. Kirsting that this is, hey, because of the risk of not getting it, you should, basically front load it and guarantee it with insurance, which then she actually got double guaranteed for insurance because of the, they ordered my client to make her the sole drop beneficiary, because all you can do is one. So actually, if he died, his estate doesn't get his half of drop, his wife does. So she not only has life insurance, but she has the drop insurance as well. So she's actually going to get more.
And the life insurance is intended to cover not only the future pension payments, but also the drop amount?
Well, when you add them all up, what she got, if she got his half of the drop because she's the only beneficiary, plus the life insurance, she'd actually get more than the amount.
But she's paying half of the life insurance policy, though, too.
Correct. That's what the order is, yeah. Again, the simple thing here is split the drop, split the pension, because, again, now my client doesn't end up with cash, and that was the argument he made at the trial court was, I'm ending up with less cash. She gets everything front-loaded. I have to wait and get my portion of the pension. And again, when they're this close to retirement, the standard, if there is such a thing, is just let it be paid. And that's actually, again, what the court ordered in Kelsch, where the Supreme Court said just, there's different ways to pay it. One of them is just defer it. And in the section where the actual public safety retirement system was arguing that they shouldn't be in these cases and so forth, which was the later part of the opinion, Supreme Court's like, no, he pays until he retires, then you pay, which is exactly what my client was arguing, which was he pays until retirement, which is done through drop, and then the public safety pension pays her equal share. So I'll save my minute and a half.
Thank you, counsel. Counsel?
Good morning. May it please the court. My name is Zelina Kirsting, and I represent the appellee, Michelle Hoobler. This court should be affirmed as it did exactly what it was in Kelsch, our Supreme Court instructed it to do in Kelsch. It thoroughly considered the equities to each of the parties, and thoughtfully and creatively came up with a solution that was equitable to both parties.
What is your answer to the idea that a court cannot order the creation of an asset?
The court ordered a term life insurance policy.
But it's still an asset.
It's not an asset. A term life insurance policy has no value until death. So as a family law practitioner, if we have cases where somebody has a term life insurance policy, it's not an asset. It's like a leased car or a rented apartment. There's no value to it. It's only if there was like a whole life policy that it would have value. So the court ordered a term policy, so the term policy only comes into play if Mr. Hoobler were to pass away. So what the court did here, so first of all, I want to clear up a couple of things.
Let me follow up on that
sure.
question then before you get on. Assuming I agree with you that a term life is different than whole life, and, or arguably it's not an asset to be divided. I agree with you on that. Something your opponent said made some sense to me. Was what the courts have said, though, you can't create a survivor benefit where the plan doesn't provide for one.
Absolutely.
Isn't the ordering of a life insurance policy the kind of backdoor to that here?
No, Your Honor. So absolutely I agree. You cannot create a survivor benefit because Title 38 has decided there are no survivor benefits. That is not what was valued here, and that's not what the court was dividing. What the court...
It wasn't just dividing the drop, though, because the drop's protected. He's the survivor benefit on. She's the survivor
correct.
On that.
So let me answer the first question, then I'll go to drop. Okay, so what Mr. Underwood valued was the stream of payments based on Mr. Hoobler's life expectancy. So basically, it was based on, the mortality tables and the actuarial value and down to a present day value based on what his life expectancy is. And so basically we were trying to say, hey, this asset has this value and we would like to be cashed out of this asset. That is what Mr. Underwood valued.
But how does it have that value if Mr. Hoobler dies 2 years after retiring?
Well, it could be, he could die 2 years after retiring. He could, it doesn't really matter. I mean,
But it does in terms of the parties should be in the same position in terms of what they have available to leave to their estate. And he has zero at that point if assuming he's earned whatever the amount, and there's nothing left over in the pension. But on the other hand, wife receives an amount that's based on his life expectancies, that he turned out not to live that long.
Okay, so again, I think we have to look at, what the parties' expectations were. Like when they're married, they're together, the community is together.
But their expectations is that they will have a pension, as he's explained. She would have an 80% pension if he dies and she's still alive. But if the law says that's not, we don't do that, there isn't a survivor benefit when someone's not married. Why does she end up being better off? And she's getting the amount based on not even just 80%, but 100% of what he was going to earn through his life expectancy.
Well, she's getting 50% of her community interest, right? So first of all, Title 38, public safety has made a decision that they are not going to provide for former spouses. They have every right to do that. But they certainly do not have a right to tell family courts what to do. And Title 25 says that family courts are required to equitably divide the community assets. So when you have to equitably divide the community assets, that means that you have to look at the assets that are before you and you have to substantially equally, is what we've defined that to be, divide them. And so here we had an expert that said, hey, this asset is worth this. And it has nothing to do with the survivor benefit. It has everything to do with, based on these mortality tables, which could be, he could live longer or he could live shorter. Yes, there is
And husband
speculation.
didn't dispute that amount.
Excuse me?
Husband didn't dispute the actuarial value.
That's correct. That's correct. There was no contrary evidence. He could have had his own expert if he wanted to challenge any of the assumptions, or the basings. He did not. So that is the evidence that was before the court. And so I want to explain drop. I want to go back to the drop issue. So what drop is essentially, this is a mature pension. Public safety says you have to work for 20 years, and at 20 years, you can receive your mature pension. And so in this case, it was calculated $78 and some change per month, $7,800. So what drop does is they say, if you choose to continue to work, now you can only work 5 more years.
I understand how that works. The point I was making is, she gets a survivor benefit from the drop portion, because she's designated.
Public safety does
So
allow.
that 1 million policy is just to cover the pension, the regular pension, not the drop
Right,
portion.
and the valuation that Mr. Underwood did was he valued the present-day actuarial value of the pension, and then the drop was just a plus.
Right.
And why would she get the entire amount of the drop? Why didn't she just get 50%?
I'm not sure that that's what the court said, I disagree. I think that you can name you can name multiple beneficiaries for the drop, as the drop beneficiary. So, I would agree that in this particular case, wife was, based on how the court divided the assets, she was to get 44.6% of the pension and the drop. I would agree with that. If she continues to get the 457 and the 401k. Otherwise, it would be 50-50 if the court were to remand and say it has to be 50-50. So basically, it's not...
But on the point of the present value discounting, and from my prior life, I understand generally how this works. But even as just assuming his life, true, you're not providing for a survivor benefit, but you are insuring against the idea that he'd die after 1 month of payments.
You're not... I'm sorry.
And which is a survivor benefit, meaning she would get more than she would have otherwise if he had died in month 1. So
I guess I would just say that, if the question that you posed to opposing counsel was if there was, if they had, $10 million or whatever, would you have any problem with doing it in that instance? And so the court shouldn't have to have parties before them based on their wealth and say, oh, in some instances we're going to...
That was from the other side of the bench. That wasn't mine. So my hang-up is, and the point where I disagree with your opponent is, I think if this had been a spousal maintenance issue, I think the court could have made the husband provide a life insurance policy to insure spousal maintenance. Like, we're going to do spousal maintenance for 10 years, and make sure you don't die before then, we're also going to make you provide a life insurance policy. Is that something that happens in family court?
Well, you know what? The statute on spousal maintenance says it ends upon death or remarriage, death of the either party,
right,
and remarriage of the recipient.
Because I've had cases where there's been life insurance policies entered as part of the decree, and we just had one recently where the guy didn't pay it and she didn't contest it, and that was later on. Does this not happen?
So, I think it does happen sometimes by agreement.
Oh, only by agreement. Okay. Well, that takes a lot of
I have never actually tried that issue of whether the court could order it absent an agreement. But I guess I would say this. We know from Kelsch, we know from DeLint, that life insurance is a remedy that's available to try to make things equitable. So if...
But I agree with your opponent that Kelsch dealt with life insurance just to cover the portion of the Kelsch payments, to make sure that she doesn't miss out on that. And that was explicit in what the court was saying, is we need to, if you're worried about her losing out from him continue working, you can order a life insurance policy for that portion. It doesn't talk about for after he dies, after receiving regular benefits. So that would be an expansion beyond what Kelsch, I think, held.
So two things. Number one, I guess what that stands for, I think what my husband was arguing is that there's nowhere in ARS Title 25 for a life insurance. So you either, it's like you kind of are pregnant or you're not. Either Title 25 allows for it or it doesn't. So if it allows for it in the Kelch instance, then it allows for it, okay? So that's that. The second thing, I guess, is this. What husband is going to get is he is going to get his pension for the rest of his life, okay? We don't know how long that's going to be. None of us have the crystal ball. But what wife was counting on is getting, being in a marriage and getting the pension as well. So it's unfair to say, husband, he'll get his pension for the rest of his life.
But she'll get it for as long as he lives as well.
As long as he lives, right.
Right, so why is that unfair?
I'm sorry, what he bargained for, and what the two of them bargained for together is, we're going to have money taken out every month. It's involuntary. So money's going to be taken out every month because we know at the end of the day we're going to have this great pension. And then he gets that. He leaves the marriage with that, he knows he's safe, he doesn't have any concerns.
But our Supreme Court has said over and over again, you got to take that up with the legislature.
I understand, but again, I would just say, Your Honor, that Title 38, simply because they want to say there's no survivor benefits, I'm okay with that. I mean, we can't change that. I mean, I'm not okay with it, but that's the way the law is, right? But that doesn't mean that the court, when faced with equitably dividing things, that they're supposed to disregard that. So I guess in this case, what I would say is, so if that's the case, if we're going to go with that, then what our position was at trial was that, there wasn't enough assets to give her everything she was entitled to. But we asked the court to give her as much as possible, to give her everything, and then we asked for a life insurance on the other. Husband said, oh, that's not fair because I'm not going to have any money right now. So in other words, he wants his half of the current, the pot that can be divided right now. But he's saying, and I know I'm going to get my pot at the end too because I'm going to get my pension for as long as I live. But I'm sorry that that's not going to happen for you. But, oh, well, that's the way it goes. So if that's the case, what would be equitable would be to say, well, then, she should get as many of the assets as possible now because then he's going to get it on the other end. And so...
the husband just gets a pension until he dies. She gets it locked in for the actuarial date. She gets a better deal than he does.
Well, maybe. I mean...
clearly. If you're giving her the actuarial value and it's not the 80%, if she'd been they'd still been married, she's locking it in based on the actuarial chart, and that's the value of the life insurance. So isn't she getting a much better deal than he is?
Well, again, I think the court, I think the court did a great job because it limited it to 10 years because they didn't want to have a windfall, right? And so they limited...
You would agree it would be a windfall if he dies after 5 years. It would be a pretty significant windfall.
I looked at the break even, to be honest with you, and I'm not sure it would really be a windfall.
Thanks for being honest.
Yeah, no, I kind of did. And basically, the 44.6% would be $34.96 a month for her, okay? So basically, if for the 10 years, so 120 months, that comes to $419,160. So let's say he lives so she's getting her pension of $419,160, and then let's say he dies at, month 120 or, 119. So then she gets $1 million on top of that. And what she was supposed to get was $1.2 million. So I guess...
But what she's supposed to get, like I say, that's different than she's getting much more than he does if he dies early. So he has less to leave to his heirs than she does.
Well, so again... I'm not sure that that's the case because he could live longer. So remember, after the 10 years, right, that's where the break even, I didn't do those calculations. But
and could I just go back? Were you conceding that she should not be the sole beneficiary on the drop?
I think that it's unclear what the court, I looked at the ruling right before I got up here, and it just said that he was to name her as the beneficiary, so I think it's a little unclear as to whether the court meant to the extent of her 44.6% interest. So I guess it would depend on if you're going to, remand and say the court didn't have the power to do the life insurance, so then I would say.
Are you disagreeing that there's any basis for doing something other than simply giving her 44% interest in the drop?
No, I'm saying that if you're going to remand and tell the court it didn't have the authority to do the life insurance, then I think it would not, I think she should.
How about if we decide the court had authority to do life insurance? What do we do about that?
Then I think the 44.6% of the drop, it would be appropriate because, and what the court recognized, and again, so her half of the drop, and remember, it's, that's a moving target because he doesn't have to work the 5 years, so it's only going to be $600,000 if he works 5 years. He can quit right now or retire right now, and it won't be that much.
But she shouldn't be the sole beneficiary of that.
Yeah, I would agree it would be the 44, but the life insurance that the court said if you don't do that, they limited it to $250. So, they again were trying to be fair and equitable with the circumstances.
Cancel if the life insurance policy does not in effect create a survivor benefit, what does it do?
As
I understand it, or at least the way it appears, is the life insurance policy in effect creates a survivor benefit. And I know that that's not what you believe it does, but if it doesn't do that, what does the life insurance policy guarantee?
The life insurance policy,
Yeah.
It guarantees the present day value of his life based on his life expectancy. It has nothing to do with him dying. It's based on his life. It's basically saying we are valuing, it's just like valuing a business. We're valuing this asset today. We're figuring out what the value of the business is today, and we're trying to figure out a way. You're going to get the business, one spouse, and there's not enough money to pay for half of the business, and so we got to figure out a way to secure those payments. And that's all it did. It just took Mr. Underwood valued this asset and said this is what this asset is worth today. And so, based on some assumptions, just like we do in, when we're valuing, houses that we're not going to sell or businesses, there's some assumptions with it, but, it's based on, approved methodologies, and that's what happened here. So,
Counsel, if I could,
Sure.
I don't want to interrupt you.
No.
I want to talk a little bit about the overtime.
Sure.
Because I have a hard time understanding what the guidelines mean and what McNutt means in this context. So the guidelines say does not include more income than earned through full-time employment, but then says, but all aspects of an income or later says if that income was historically earned and anticipated to continue in the future, we can include it. So
again, I think it's a discretion for the court, and basically what the court has to determine is, what's the historical practice of the parties been, because, the goal of the guidelines is for the kids to, after the divorce, maintain the same lifestyle, if you will.
right. Well, so I'm torn on this one because it seems like we're only talking about a year, right?
Yeah,
Okay. So the evidence is for 7, 8, 9, 10 years preceding, he had worked a lot of overtime.
Mm-hmm.
He gets up and testifies, I'm not going to do that anymore because now that there's a divorce, the only way I'm going to have any interaction with my kids is to cut back on my overtime hours. That's really all the evidence. He didn't put on other evidence to show that he was going to continue to work it.
well, I do think that there was some evidence in the record about him, being called in, whenever, sometimes having to work 20-hour days because of the nature of his position.
Historical.
Right,
Okay.
and he would get paid for that, right?
Right.
So I think that, there was no evidence to suggest that wasn't going to change. I mean,
Well, he said, the evidence was that he said, I'm not going to. So I agree. The court could, I guess, have theoretically have said, I disbelieve his testimony that he's not going to.
Sure.
But the court didn't say that.
Well, I think, the court has to look, this court should look at this in perspective. Basically, the court attributed an additional $1,500 a month to him, which
It's a lot less than what he had historically.
A lot less, and a lot less than what we were arguing for. So again, I think that basically the court said, yeah, I recognize you're not going to do everything that you've been doing, but, you're good, we're not going to just say it's your base. So I think that, again, that was something that, the court had the ability to assess the credibility of the witnesses.
And the court doesn't need to make an explicit credibility finding on the record, does it? The court doesn't need to make an explicit credibility finding
No, of course
on the
not.
record.
Of course
does
not,
it?
no. But I think that, again, you look at historically what's happened here, and, that the likely, his job required that kind of thing, so.
Doesn't that essentially set a presumption, though, that if you've historically done it, we're going to presume you're going to continue to do it no matter what you say?
I don't think so. I think it's a case-by-case instance. So I see that I'm out of time, but I do want to ask the court for attorney's fees. Husband is in a much better position to pay. I believe his positions have been unreasonable. We would never have been here if we would have just been able to negotiate the life insurance policy. So thank you. Appreciate it.
Thank you, counsel. We appreciate it. Counsel? And counsel, can you address the term life insurance as an asset or not?
Term life insurance can be valued. There is case law on that. I can't remember it right off the top of my head. For example, if you got life insurance before you got cancer, and then the cost would triple afterwards, there are cases they value term life insurance policies, because especially if you can't get another one, then the cost and so forth. So you could inequitably give something to somebody for free that the other person would have to replace at a cost of 10 times the amount. So there are cases that value term life insurance.
Would you have any objection if she were responsible for paying the entire premium?
I think so. Again, it's going around the statute of creating an indemnification. I mean, really the closest case to this is the Howell case. It is, the legislature says you don't get this, and a court finding a creative way around it. And I quoted in there something from the oral argument at Howell at SCOTUS, and coincidentally I quoted it at Barron when I did the oral argument in the Supreme Court here, which is if it's this easy to get around the statute, that's what gives law a bad name. It's not, if the legislature says you can't do something, the court can't create a creative way around it, just in the concept of equity, which is the entire Howell, which is why the U.S. Supreme Court overturned, essentially 30 different states that used an equitable arena or equitable concept to get around the specific language of what the legislature said you cannot do. How much time?
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.
Thank you.